Actually, of the three panels, this is the one that I'm most excited about. When I first heard about this opportunity 2 years ago in England, I thought that it was one of the best ideas that I'd heard in my career. It's an opportunity for plaintiffs to manage risk and to manage costs and to share all of that. It's called third-party funding, and we have an unbelievable panel for you, and they're going to explain to you what it is. But up until a few years ago, there weren't very many third-party funders. There were none in Canada. There were no bricks and mortar funders in Canada. You could reach across the border to Washington or Boston or New York and find some assistance, and as well as in Europe, because third-party funding in Australia, the United States, and England was quite mature. Today, in Canada, we have two existing, IMF Bentham, Nomos Capital, and possibly Burford Capital, depending on whether I can convince her to come here. We also have firms that are looking at in a more private equity investment portfolio approach, like Balmoral Wood, which is a litigation finance company that's in Toronto, that are engaged in this process, and the process that these people are about to tell you about. My takeaway for you, my going in proposition is that you probably have never used it, but hopefully by the end of this session, you will have a fresh view on whether or not it's one of the most important assets you can have if you're in a dispute. And I think you're going to find that that is exactly the case. So let me introduce the panel to you briefly. And on the far side is Tom Price. Tom is one of our partners in England. He's over 20 years experience in arbitrations, and spends a great deal of time in Europe, the Far East, and focuses largely on energy, natural resources, and construction. Beside him is Mark Crane, who's one of my partners in Toronto, one of the leaders in our arbitration group. His emphasis is with respect to construction, fraud, and enforcement. And then we have the two real experts here. TANIA SULAN, who is on the end here, was a serious, sophisticated litigation lawyer in Australia for many years, doing bet the farm litigation. She helped set up the third-party funding organization there and in Adelaide, and has now come to Canada with her family and is trying to project into this country as well. Having met her, she is a remarkably accomplished and determined person. I have no doubt that she will succeed. I described her as the chief investment officer in one of the powerful forces that began third-party funding in Australia. She told me that she was only a small part of that in Australia. I told her that I was going to keep it just the way it was, and she could change her CV accordingly. And then beside her from New York City is Emily Slater, who's a director at Burford Capital. Burford Capital is a force in this industry. She was, prior to joining Burford, a very senior litigation lawyer at a powerhouse law firm doing very high-end securities and other types of litigation. She too is extremely experienced and knowledgeable with respect to the topic we're going to talk about today. I'm going to ask the panel a series of questions as I did in the first panel, but we're going to do something a little different. I'm going to ask, if I can, TANIA and Emily to explain to you what third-party funding is. Just make it real for you and understand why I'm so excited about it and why I think you're going to want to do it when you leave here. Tanya, you want to go first?
Yeah, so I'll kick off, and Bob, I'm delighted to be here. Also delighted to have the promotion. I'll put you in touch with my bosses in Australia.
I'll negotiate it anytime.
Sounds perfect. I think you're right. Up until probably the last couple of years, litigation funding's been little known in Canada, and I think where there has been activity in the litigation funding space in Canada has been in the personal injury and class action realms. But with the advent of players like Burford and Bentham and Nomos into this market, we're really very focused on commercial litigation cases and arbitration cases. So that's a real evolution in what's happening here, and the market's becoming increasingly sophisticated in knowledge of the products. But on a very high level, third-party funders typically cover all or part of the costs, legal costs and disbursements associated with litigation or arbitration. A litigation funder can also cover any adverse costs that are associated with the litigation or arbitration if it's being pursued in a cost-shifting jurisdiction. We'll get a little bit more into the depths of some of the products, but just to give you a high-level overview of how the process works and how you might approach a funder, I think probably my experience is about 80% of our applications for funding come through law firms. We often get queries directly from clients who are just really wanting to explore. They might already have lawyers in place, they might not. And we'd enter into an NDA pretty early on to protect the privilege and confidentiality of the information that needs to be shared with the funder. And then we go into, we'd do some high-level analysis of the case, and if things are stacking up, we would enter into a term sheet with the clients and the lawyers as how the structure of the deal will look going forward. I think Emily's going to talk a little bit about some of the due diligence criteria that funders typically look at.
So the diligence process is a combination of both analysis of the case itself, the merits, the damages, and the overall economics of a potential investment. So when a party is seeking litigation finance, one of the most important pieces that needs to come into place is getting an assessment of what we think the cost of the litigation is going to be and what the potential upside is, since the funder will provide non-recourse capital for fees and expenses, but of course wants in return a recovery from the potential proceeds from the case. So the funders will typically take a good hard look at the merits of the case, and for Burford, we really like to have a case. It's good that most cases come to us through lawyers because we do really need to have a lawyer to have done an initial assessment of the case. Sometimes a case will be fairly well developed and along, there may be a draft statement of claim or a draft complaint already put together. Oftentimes in the arbitration space, there'll already have been a notice and they're in the middle of the sort of cooling off period and in the process of developing a statement of claim. So we will take a good look at the risks in arbitration. Obviously, there's always jurisdictional risks that come into play, particularly in the treaty space where you're talking about a contract arbitration. There's usually less potential issues on jurisdiction for an arbitration panel, but in the treaty arbitration space, where a company may have a claim for expropriation or harm to a foreign investment, there are often jurisdictional defenses for the respondent. And we'll then take a good look at the case in terms of what do we think of, is there a real breach of contract here? Is there a breach of the treaty claims? Is there sometimes, particularly in the US in commercial arbitration, there may be an underlying contract that obviously gives rise to the arbitration clause, but the dispute might be not a contract-based dispute, and that might be swept into the arbitration process as well. So a trade secret case or other kinds of collateral litigation or disputes that might arise between the parties. So we'll take a good hard look at the facts and the underlying law and legal merits. Depending on the jurisdiction, obviously in the U.S., there's often a choice of, generally in arbitration clauses and contracts, there will often be a choice of law provision. So we'll take a look at the local law and then do an analysis of the damages. And on the damages analysis, obviously, if there's some expert work that's been done early on as part of the process, that's extremely helpful to us. But I think, oftentimes that has not been done. It's expensive. And for us, I think we need to get a sense that the case is big enough to support the payback of our investment in the case, for the client to have a substantial, we really want to have the client have most of the upside in the case if the case goes well, for us to have a return, and if the lawyers are participating in risk sharing, for the lawyers to have their piece as well.
I don't know if you have any particular metrics around what you look at in terms of likely budget to claim size, but we typically look at a ratio of what we think a realistic estimate of the budget relative to a realistic estimate of the claim size of about 1 to 10.
Same for us, yeah. So we like to have room because obviously most claims settle and they settle at a discount. So we really do want to have room for a claim to have gone a fair way through the process, may have incurred quite a bit of expense, but for the parties still to have the right incentives to settle.
Yeah, and I think the other aspect that I think undoubtedly you do as well as we do is sometimes if there is a close damages analysis that needs to be done and perhaps there's not money or resource to get that initial expert report, we might provide some funding at that preliminary investigation stage, even before we've committed to the case, just to shore up some of those aspects. And the other aspect that I think is super important for funders to look at for obvious reasons is recoverability and enforcement from the defendant.
Okay, we're going to come back to you in a minute. Let me ask Tom a question. From your experience as the lawyer dealing with the client, what are the benefits? Why is this trend growing in your experience, and what are the benefits to the clients you have that have used it?
I think it's two things, and they're related and possibly even opposite sides of the same coin. The first is that, and these will be all points very obvious to you, fighting litigation is, as far as costs is concerned, is just, well, first of all, it is a relentless, if you are doing it on a non-funded basis, if you're just paying your lawyers by the hour, which is still the traditional way for litigation and arbitration, even if there might be elements of fixed fees in there, it's ultimately still a per hour game. And so you end up with just relentless monthly bills, and a lot of that is outside your control. So even if you are the claimant, you do not know what those are going to be on a monthly basis. They may depend on whether the other side is tactically, playing an aggressive game, and there are all the other uncertainties with that. So you've got relentless bills, uncertainty, and litigation funding effectively takes that away from you. It becomes not your problem, but well, not the funder's problem either. If they're happy to fund, then that's the solution. So that is in part, it's to address that evil, I guess, which is why litigation funding has grown. But just a little bit of history, and I think certainly this is the case from the English perspective, and probably in other jurisdictions as well. There have been, of course, other ways of funding litigation. Traditionally, conditional fees, where the lawyers effectively are taking the risk because it's a no-win, no-fee. So if the case is not won, then the lawyer gets nothing. If the case is won, the lawyer gets an uplift. In the UK, that used to be an uplift of 100% of the fees. That was the maximum uplift. Those were very popular in the UK until they were made unlawful about 5 years ago. I say unlawful, or that you can still enter into such an agreement, but you can't recover the uplift from your opponent. And that was a big change, as I say, about 5 years ago. That's made conditional fees, certainly in England now, effectively dead. No one really uses that. What's the other alternative? It's contingency fees. Obviously have been very popular in the US, have never caught on in the UK, and that might be to do with our innate caution. But I think it's a little bit more than that. It's that the regulations which allow contingency fees are drafted in such a way that it's very difficult to exit those, and also you have to have a full contingency fee. You can't have a partial contingency fee. So once you've got all of those difficulties in the way, litigation funding really does present the solution to a certain particular type of case, and clearly not every type of case. There's more I can say, but I'll save it.
The one question that I have about that is litigation may or may not be an asset, and there are different ways of financing that. What's your experience with the benefit to a client when they want to manage the outflow of cash, and how they use the relationship with a third-party funder to do that?
Well, that's absolutely right, and I mean it's. I guess the point is that litigation funding is not necessarily a situation where the funder has to fund all of the costs. You can have hybrid situations where the lawyers take some of the risk as well by doing a conditional fee from the lawyer's perspective. So there is definitely risk sharing that is going on, and I think that is certainly one of the appeals to it.
One of the things that I've heard from clients and from these ladies is when you get into large-scale litigation or arbitration and you're sending bills of a couple $100,000 a month, that may not be the easiest way for a company to manage its cash flow. And if instead of spending $100,000, $200,000, $300,000 a month on expenses for lawyers, they can enter into an arrangement and share the risk and have a third-party funding arrangement, that allows them to manage their cash flow on their balance sheet much more effectively.
And with more certainty, I would just add,
Right.
because what in-house counsel and CFOs are telling us more and more, as you know, is that it's sometimes not so much about the cost of litigation, but the transparency and the certainty of it. And if you're able to provide clarity as to what that's going to be, whether you can robustly participate in the litigation or not, then it provides that transparency so that the business can go on. I would also add that I think it provides an opportunity for access to justice for some, because for some, litigation funding may be about ironing out lumpy cash flows. For others, it may be they just don't have, they otherwise would not be able to robustly participate in the process.
And I think, I'm not sure whether there is empirical evidence of this, but certainly the 2008 financial crisis, I think, did mark a watershed in terms of litigation funding becoming mainstream, and that was simply because there were companies that just did not have the cash to progress litigation and were looking for alternative means.
We're talking about sharing risk. Mark, what is the law if in Ontario, and then I'll ask Tom about England, with respect to the question of privilege? You're now engaged with a third party. How does that impact, if any, the privilege that you have with your client?
Yeah, so that's a good question, and I have to set out that as it relates to, because normally, I guess if I back up, you have a solicitor-client relationship, and it's the client's right to waive that privilege, and they will do so oftentimes if they inform a third party about the receipt or something relating to an opinion relating to legal advice. And you're going to have the third-party funder, in order to, we've heard from Emily and Tanya, in order for them to do their due diligence, they're going to want to collaborate with counsel, share opinions, or perhaps be informed of an opinion from counsel, and that on its face you think may give rise to privilege issues. I think there's two ways you can look at this. One's through the lens of litigation privilege, and the second lens is through common interest privilege. I think litigation privilege, if the communication would say, if the communication that you were anticipating sharing, or you do share with the third-party funder or the proposed third-party funder, was prepared for the dominant purpose of litigation, that's either contemplated, pending, or in process, then you would argue, I say, that you've fallen under the benefit of litigation privilege, as you would perhaps through analogy with any experts that a client and or the lawyer may retain to advance their litigation interests. So that's the position, I think, you would take in Ontario. I have to tell you that there's scant case law on it, though, and so you have to. I think there perhaps is some risk, and you want to be cautious about that. But that's the approach I would take. Certainly, I think the other approach you can take is that there's a common interest privilege as between the client and the third-party funder. The common interest, I think, argument is not quite as strong. You may have a common foe. They have a common interest in the outcome of the litigation. But I think the distinction perhaps is that you don't share the common foe. I'm not sure that you may if the third-party funder is going to eat sort of a costs award or something, but on its face, I'm not sure the third-party funder shares the same adversarial nature with the foe, and I think that perhaps sheds some weakness on the common interest privilege argument.
Let me ask Tom and Tanya a question. Tom, you can go first. If you're talking about settlement, what's the role of the third-party funder in that issue vis-a-vis the lawyer's relationship with the client?
Well, essentially, although Tanya will obviously give the view of the funder should really be standing away from that in order certainly to avoid allegations of maintenance and champathy. I mean, it is a question for the client and the lawyers. So in practice, that may not be entirely how it pans out, but certainly that's the theoretical position.
I think in large part it depends on the jurisdiction, and it does come down to issues of maintenance and championing and funder control. So in Australia, I think the way that the laws come out is that funders can be quite involved in the cases, probably more than actually as a funder we would want. But under our contract and the contract that we are using in Canada, and hopefully we'll get some more judicial guidance on it as we move forward, we have a dispute resolution clause in our funding agreement, so that if there are offers of settlement and there's an irreconcilable dispute as between the client and the funder as to whether the case should be resolved, then it goes off to a short fuse arbitration. It's a very blunt tool in a situation where you often need expediency. In our 17-year history, we've never had to invoke our strict contractual rights, but it's there. And I think the reason that a funder looks to have that kind of input into a case is that if, particularly in Australia where there is no ability for lawyers to charge contingency fees, where we're often paying all of the costs and carrying all of the risk of a litigation, it becomes easy for a client to say, well, I think this settlement offer is unreasonable and I want to go for more, even in the face of advice from the lawyers that it's within the realm of a reasonable settlement range. So it's really a clause that's in there for a situation where you've got a client who's no longer being particularly commercially reasonable about an offer that's on the table, but as I said, seldom used.
And you know, Burford's funding is primarily in the U.S. and international arbitration, and we actually, you know, I think it is driven somewhat by the jurisdiction, but you know, typically driven by U.S. law. We are very passive, and we don't have a right to settlement control. We have a right to know that there's an offer, and I'm sure we'll offer. We do frequently offer an opinion on settlement. But you know, we really are, just because of the state of the law and because of our, you know, just wanting to make sure that we're avoiding any interference in the client-lawyer relationship. We are very passive, and our agreements don't provide rights to impose settlement. And just to sort of circle back a little, I think we mentioned up top on the non-recourse basis of litigation finance. So a case does, we don't recover anything if the case isn't successful, and our return is capped by the ultimate recovery of the case. So even if we have a return entitlement that's large, if the case doesn't end up recovering or settling at an amount that provides us our full entitlement, we're really capped by what the ultimate recovery is. So it can be some difficult conversations when a case doesn't go as well as anticipated, and there's usually a negotiation between us and the client and the lawyers if a case is settling. But it is. I think it is the case where it gets to be difficult, where the lawyers and the funder are the ones seeking the risk and the client has control over whether to settle or not, and those can be some difficult negotiations, but usually do resolve without too much pain.
Is there a typical timeline of recovery that you and your industry target in your assessment of a case?
Just speaking for Burford, and I'll let TANIA speak for Bentham, we obviously, our returns are time-based, and how we report to investors is IRR-based, so we obviously are very concerned about how long a case is going to take. I think very often we have more realistic expectations about how long a resolution is going to take in a case than the parties and sometimes the lawyers do. But we typically build some time-based components into the economic terms, partially because our capital is out, partially because we want to incentivize clients to be commercial and reasonable when there is an opportunity for settlement and things have been going for a long time. But we don't have, Burford has permanent capital, and unlike some funders who have more of a private equity-based fund structure, they're looking for an exit in a relatively defined period of time, and Burford and I think IMF Bentham are sort of here to stay in terms of a litigation partner, particularly in some very large, when you're talking about very, very large and substantial litigations and arbitrations, they really do take a long time to resolve. They can often take 3 to 5 years at least, and sometimes longer for the largest disputes. So you want to have a partner that's going to be able to be there and isn't looking for an exit.
So we've talked a lot about benefits and theories and how things may work. Can I ask each of you to give an illustration, just a concrete case that you've actually done where it's worked out well for the client, how somebody here might actually go away and say, that might work for me, especially given that example you just gave?
You want to go first? Okay.
So, as Bob mentioned, we set up here 18 months ago, and we've looked at about 180 cases. Of course, in 18 months, we haven't seen any cases through to completion here in Canada, but so I thought I'd give you an example of a case that we'd had in due diligence. And the client was a resource company out west, was involved in a dispute regarding one of its oil fields. At the time that this client came to us, they knew very little about litigation funding, in fact nothing, and they had been told about litigation funding by their accountant. This client is by no means short on cash, but they're in the mining industry, and given the state of the market at the moment, they were very keen to make sure that they're using their resources wisely. And so when we had some initial discussions with this client and the CFO was involved, and he said something to us like, at the moment we were faced with a decision as to whether we continue to explore our mining assets or whether we pursue this piece of litigation. It was a real choice as to whether they might want to do both with their available cash and how they were going to finance those activities. And he said, with Bentham's money, we can do both. We're experts in drilling wells. You're experts in funding litigation. So now, hopefully now we can do both, and both will yield results. But if they don't, I'll still have my gas well. And for our part, hopefully we'll yield a result. But I think that anecdotally, what he said exemplifies the key benefits, or two of the key benefits of litigation funding for these types of clients who do have cash, but need to think about where they allocate their resources. And the first is that it's a smart way for a company to pursue litigation, which is, as we've heard and talked about, or an arbitration, which is inherently risky, without any risk, either to cash flow or if the case is ultimately unsuccessful, because a funder will pick up any adverse cost orders. And secondly, it really assists companies with their resource allocation, and that's a key thing that was of interest to this client.
Tania's talked about a company with a single case. We work with both law firms and companies to provide capital, and we have done quite a bit of work with providing what we call portfolio funding to law firms to provide capital for the firm to manage risk and take on cases across a whole group of cases. And we like it and they like it. They can grow their business and take on a risk, which a lot of firms have not had a lot of practice doing, and grow their business. And we like the diversity across a larger pool of cases. But one that we have in, more specifically to companies, I think we can work as well with companies on portfolios of cases for the company. So in companies in the extraction industry or in the construction industry, a lot of times they may have multiple groups of cases, disputes. Sometimes they're claimants, sometimes they're respondents, sometimes they have counterclaims, and we can help provide capital to the company across the whole group of cases. Allows them to get certainty on what their litigation spend is going to be. They may want to offload all of their litigation spend to us, and we can do that and take on substantial obligation to the company to provide capital over a long period of time. Or that maybe they want to have certainty in terms of how much they're going to spend. They're willing to put in some capital, but what they really are looking for is to flatline their expense and know that they're not going to have incur expense over that amount, say, several $1 million a quarter. And we'll put in the additional expense over and above. So, and that way we can help companies, again, manage their risk exposure, manage their, a lot of companies, they defend cases and they feel like they have to do that, but a lot of times are reluctant to bring claimant cases, partly because they don't want to enter into a dispute with their business counterparties, and partly because it's risky and they may not get a return on their investment for that. So we can help the companies manage that risk and manage their cash flow. And not only does it help them just manage their cash flow day to day, but for public companies, it can really make a difference in valuation because they're taking that above the line litigation expense out of their EBITDA. And that really has a big difference in shareholder value and valuation of the company.
Tom and Mark, can I just ask you to comment on something that I would have thought would be quite a sensitive issue for a client in third-party funding? What is the law with respect to whether or not those funding agreements have to be disclosed? Are they kept private or do they have to be disclosed? Tom, what's the rule that your experience in Europe is?
So they don't have to be disclosed as the starting point, and I think the rationale for that is that whereas, say, a conditional fee agreement would have been because there was an uplift which the other side would be liable for if they had to pay those costs, there isn't actually any particular reason why the other side does need to know that there's a funding agreement behind it. Having said that, there are circumstances in which the funding agreement will come out, and that is possibly, or sort of classically, in relation to security for costs. So a claimant bringing a claim by virtue of the fact it's sought funding might be evidence that it has no insufficient funds. The defendant may apply for security for costs in the event that it wins, that it has security for a costs award. And then the question arises, well, you need, as the claimant, to then disclose the funding agreement to show that you've actually got sufficient funds, and it may be that your funding agreement is going to cover that security. So that's a situation in which that might come out. And that just dovetails in with a point that I wanted to make at the beginning, which was about why these litigation funding generally is becoming increasingly popular. And that's in the area that we'll come on to in the third session of investment treaty claims, where you've got claims for a lost investment against a state, where in fact, as a result of that expropriation, simply the investor has no money and therefore needs funding. That's the only way it can actually bring the claim. So I just wanted to make that point. That's another reason why these funding agreements are increasing in popularity. But to go back to your question at the beginning, Bob, there is no, as far as English law is concerned, and it may be different in other jurisdictions, no actual requirement that they should be disclosed.
So it's quite different in Ontario, and I guess by backdrop, if you look at the Domestic Arbitration Act in Canada or the International Arbitrations Act, that there's no doesn't provide any insight into third-party funding at all, frankly, whether it needs to be disclosed or not. But if you look at, through analogy, the courts, certainly the courts in Ontario, there's an expectation that if a party enters into a third-party funding agreement, that you bring that to the attention of the court at your earliest convenience. The agreement will not be in effect until it's been blessed by the court. It may or may not be blessed by the court, but there's nothing to say that there's nothing necessarily that would amount to maintenance or champerty about a third-party funding agreement, but the court needs to find it reasonable before it'll be considered in play. And then you look at it through the lens of an arbitration agreement, and I think an arbitrator in Ontario would have a difficult time being persuaded not to follow that case law in Ontario because it's consistent. It's becoming, there are more decisions. You tend to see it come out in the class action context, but I don't see why that analogy why an arbitrator wouldn't be persuaded by that case law. And I think you'd want to do that for a couple of reasons. One, it gives rise to a conflict issue. I think you will want to clear conflicts with the arbitrator vis-a-vis the third-party funder, and I think for a couple of reasons, including enforcement. But so I think as part of the clearing of conflicts, you want to have transparency and be open and candid about whether there is a third-party funder involved. And secondly, to the extent you don't disclose it and you get an award and you go to seek to enforce it, I think it gives rise to at least a potential argument from the losing party that the award shouldn't be enforced because there was no disclosure. Certainly if you're going to be in Ontario, and even if you're not in Ontario, I'd hate to run the risk of trying to enforce a judgment abroad if there's a potential argument to be raised by a party that disclosure of the funding agreement ought to have been made and it wasn't. And I think certainly if you look at some of the international arbitration centers, they are coming out now with recommendations that you do make disclosure to the arbitrator, both for reasons of conflict and for transparency purposes.
And I think some of the international trade agreements, for example, the Canada-EU trade agreement now has an obligation in that agreement that if you are pursuing an arbitration and there's litigation funding involved, then you have to disclose, I think it's the name and the fact of the funding, not necessarily the agreement itself. So right. It's that's an interesting development.
Yeah, so the name, I agree. So the name and the fact that there is a funding agreement and the name of the funder, you'll see the commentary is not privileged, and I think you can get into a debate as to what may or may not be privileged within the funding agreement. Certainly, I think if you're going to get a funding agreement blessed by the court in Ontario, people will redact certainly the lawyer's fees or potentially the view on, will typically be redacted, but certainly the name of the funder and the fact that you've got a funding agreement wouldn't be protected by privilege.
Although, just quickly, in the U.S., the courts have generally found in U.S. litigation that the funding agreement and the funder itself is all subject to attorney work product and have been generally protected from disclosure. I agree that there has been in the arbitration space a movement towards disclosure, in particular just to ensure transparency and lack of conflict. And I think it's frankly in the funder's interest to have an enforceable award at the end, to be conservative and cautious about making sure that there's disclosure at the beginning, so you don't put you've already invested millions of dollars in something that now becomes unenforceable.
So we're at the end of the time we have for panel 2, subject to anybody that has questions for them while they're here.
Yes, Scott Fraser at Watson Milligan, and I'm involved in a lot of construction disputes. And my question really is, are you seeing owners or contractors come to you for
Both.
these services?
Both. There's both. I think, it just depends, on mega contracts where there may be a dispute between a subcontractor and the ultimate contractor. We're seeing parties come to us there, and we're seeing companies coming to us that are huge major brand name companies that may be the main contractor on a project and maybe subcontractors on different aspects of it. And all of it doesn't really make a difference to us, really. I think, to us it makes a difference of just, what's the strength of the claim and the potential recoverability. And, in those construction disputes, there's almost always counterclaims. So just sort of looking at the whole package together.
Chris?
I'm litigating right now against a party that's getting third-party funding. And in that case, I'm concerned that perhaps full disclosure hasn't been made to the funder, or if there's some sort of misrepresentation that's been made. It turns out that that's the case in one of your cases. Your client hasn't made full disclosure or made some sort of misrepresentation to you. What happens to the funding? And do you have recourse against that client? Is that a risk for the client when they get third-party funding?
Well, under the terms of our funding agreement, if there's been a misrepresentation as to a material fact, then we have a right to terminate the funding agreement. As to whether we would pursue the client, I think it would be a very fact-specific situation. I think in the grand scheme of things, it's probably unlikely that we would take a proactive action against a client. Hopefully our due diligence system is enough to pick up these kind of things at the outset, but as everybody knows, as litigation unfolds, things come to light, and so I think having that ability to be able to extract ourselves from a litigation that's no longer viable is very important.
Yes, my question is more for TANIA. The panel talked about class actions and what the Ontario courts have said about funding agreements. A couple of weeks ago, there was a decision by Mr. Justice Burrell, which made positive comments about some portions of the Bentham agreement, but rejected some other portions of it and said, I approve this agreement based on those portions that I disapprove of being basically either changed or deleted. Mm-hmm. Where do you see the future of Bentham being in the class action funding scenario within Ontario?
It's a good question. I think there will be some appellate consideration of Justice Perel's decision. I think that you're right. He was quite supportive of the concept of litigation funding and saw it as a positive development. But from our perspective, there's a couple of aspects of his decision that are problematic. The first relates to a funder's termination rights. So under our contract, as I alluded to, we've got a right to terminate our funding if the case is no longer, in our reasonable opinion, commercially viable or no longer has good prospects of success. So as we all know, as litigation arbitration proceeds, things come out and it's a very rare event, but we need to be able to get out of our obligations if that arises. And in our 17-year history, we've terminated one funding agreement on the basis that the client was engaged in some activity that we thought was less than honest. And the reason for that is that we remain on the hook for adverse costs for the period that we're funding a case. So if we terminate an agreement, it's a huge decision. We might have sunk millions of dollars already into the case, and then if we can't negotiate a discontinuance with the defendant, we will remain on the hook for adverse costs for the period that we're funding the case. So the case where we did terminate our agreement, we paid $750,000 in adverse cost orders. And so it's a significant and not a lightly taken decision. So that's one aspect that I think needs some clarification in his decision. And the other relates to returns. And it's a very class action specific decision, so I won't go into the nuance of it. But I think in broad strokes, it's important for a litigation funder to know what its reasonable returns might be if a case resolves within certain parameters. And Justice Perel's decision doesn't give that kind of certainty, which means that litigation funding for class actions in Canada might become a more tricky proposition if we can't get some clarity on that.
Anybody else? Okay, then let me just thank the panel, and Obviously, we got very lucky, 2 remarkable experts, and hopefully I didn't overstate the sales job at the beginning, but I do believe it's an exciting opportunity and it's going to be taken up by a lot of clients. So we're going to go to panel 3 now, and it'll be a bit shorter than the other 2 panels, and we're just going to change and keep at it.